So what are community care services? You can see the list there. What we've done is to provide what we've described as a short and a broad list. There's a list of services: residential accommodation, clearly, community and home-based services, advice, social work, counselling and advocacy, and financial and other assistance. But we haven't stopped there because, of course, not quite as simple as that, and so we've come up with this hybrid solution whereby the services will include the services but also the list of outcomes. So health and emotional well-being, protection from harm, education, training and recreation, contribution made to society, and securing rights and entitlements. They are all part of the services which the service user or the carer, depending on who it is, would be entitled to. Right, so far as the provision of services is concerned, care and support plan I've dealt with, so I don't see anything more about that. So far as personal budgets are concerned, they are a growing market. The government is keen to encourage them, and so we're suggesting that there are regulations which deal with personal budgets. So far as residential care is concerned, at present, direct payments do not extend to the provision of residential care. We have recommended that that should be the case. There has been some concern expressed about that as to whether that will change the market, because instead of a local authority then block buying residential care, you've got numbers of people making their own individual arrangements. We don't think that's right, having looked at it and had some sort of economic research done. But even if it was, the sort of the default position, if you like, is that the direct payment is made by the local authority. So if, for example, the arrangement with the care home was not working, then the local authority would be able to step in. So it's one of those concerns which we can understand the concern which is being expressed, but which we didn't think would actually be the case in practice. Choice of accommodation provisions, we're saying, should be enshrined in regulations, so that there is statutory backing to people who express a preference for where they want to go, and they should be entitled to do so. And so far as charging rules are concerned, that would also be set out in regulations. Next, the position on safeguarding. Again, this was an area which was reasonably controversial through the consultation process, and we've changed our mind on various of our ultimate recommendations. What we are saying is that social services should have the lead as the coordinating agency where there are occasions of concern about adults at risk. It may be that they ask other agencies such as the police to become involved and to carry out the investigation. If they do so, then the police will have to report back to the local authority. So ultimately, it's the social services authority that will remain in the driving seat. They will have the statutory responsibility as the lead authority in those situations. So they can either carry out the investigation themselves, or you've got the example of the police where they would ask them to do it, or it may be that they suggest that there is a tripartite investigation, including workers in the NHS. It will all depend on the circumstances of the case in question. I mentioned about the controversial element of our proposals in consultation. We were anxious to do away with the concept of vulnerable adult because we felt that that was regressive. It implied that the adult concerned was a victim. but there was considerable divergence on consultation as to whether that was right, and many, Department of Health included, had reservations about our proposal, which was that they should be referred to as an adult at risk. And that would be someone who has health or social care needs, who is at risk of harm, and who is unable to safeguard themselves. But not only that, it's got to be that the local authority thinks it's necessary to carry out an investigation. Can I just go back? I just want to say a bit more about the that. In terms of harm and what does that mean, we had, as part of the original proposals, that the person concerned should be at risk of significant harm. And we ran into all sorts of disputes and arguments at the consultation about what does significant mean. So we've deleted significant. As you can see, it just appears to be at risk of harm. But harm would include financial abuse, for example, which can happen with other relatives in the family, and it can happen through physical harm, obviously mental harm, but also it would include self-neglect. So we've cast it as wide as we think it's appropriate to do. Also on safeguarding, we haven't gone into whether there should be emergency or compulsory powers. We've said we're prepared to go there, but only if the government wants them. So as a result of our report, there are no new emergency or compulsory powers. Well, if people want to ask maybe further about that in the questions and answers, then please do so, but that was our approach. What we're also suggesting is that Section 47 of the National Assistance Act is repealed. So that is where local authorities would have the power at present to go in to premises where there are insanitary conditions, and we felt that that could be met under the environmental protection legislation. But also, if someone was removed under Section 47, they then have no way of immediate challenge to that for a period of some 6 weeks. And so that's not compliant with the European Convention. And generally, our view was that the provision is no longer legally sustainable in the current climate. So that's why we've recommended that that is repealed. If the government want, or the Welsh Assembly government want to go and look at that area, then we've suggested that they do further research before coming up with a proposal relating to it. And we've also suggested that there are statutory safeguarding boards. There are, so far as those boards are concerned, to be 3 compulsory members, if you like, and they are the Social Services Authority, National Health Service and the police, and then a range of other bodies who may be appropriate to co-opt as members of the board. And so far as that proposal is concerned, that is one which the government has already said it has accepted, and so that will be in the statute come what may. So far as the safeguarding boards are concerned, we don't envisage that they will be there just to carry out investigations, though clearly that is very much part of their role. They are there also to provide biannual reports, to provide guidance about best practice. So their existence is to disseminate information that will be of assistance to agencies in carrying out what is work in a very sensitive area.